Yeah, the last thing you want to do, I've seen before where the case is going your direction, and the attorney that is going in their favor gets emboldened a little bit, and they start talking and they say the wrong thing, and the judge says, you know what, I didn't like what you just said, so I'm going to basically backtrack and go the opposite way here.
Yeah.
So you don't want to do that.
What is going on, everyone? It is Mark Reel, the Father's Rights Attorney, and I am here today with Orange County Attorney Rafael Serrano, and we're going to talk about how judges impact your family law case. Rafael, how are we doing today?
Good, Mark. How are you?
I'm fantastic. So this is a really interesting topic, and a lot of times someone who's not experienced in family law or hasn't been through it doesn't think about, but family law is so much the opinion of the judge, and what the judge sees in that moment is how much a judge can impact your case. So I'll start it out with this. What are the different types of judges you see, and how can that change how we address or start a case?
So there's a million judges out there, and you can be in front of any type of judge on any given day, and some of them are very, give me the facts, give me the solution. Others are trying to see, give me more of a story. I want to know more what's going on. I want to actually see pictures. I know one judge that says, show me pictures of the children before I even get to your case. I want to see a picture. I want to hear about how their day is, how their school is. Other judges are just, I want you guys to come to us with an agreement. I don't want to make an order. And so there's, what judges you're going in front of for the most part. And so kind of what you're going to be getting into. What it comes down to is knowing that judge's style and what they like, and whether, not saying either one of them is good or bad, but just knowing how to present it in a way that they want to see it.
Yeah, definitely. Because like I said, you have the judges who you walk in, and if you come to an agreement, well, what do you want? Well, what do you want? All right, well, I'm probably leaning that way. Why don't you guys go in the hallway and figure out, which there are pros and cons to that.
All right.
The pros are you get to individualize it to your family. It's not a judge slapping something on you. The con is that in that limited what the judge hears, if they lean towards the other person, you get a less than desirable outcome. Mm-hmm. Probably my favorite, and I think the ones that get it right the most, are the ones you talk about. That's like, hey, what are the kids' names? Do you have pictures of them? How old are they? And they really, really get to know the situation.
Right, and what it does is it kind of makes everyone put their guard down. Mm-hmm. They lay down their weapons, and they just say, what are we trying to do here? And oftentimes, in fact, all times, I think, what you're trying to get out of that court date and out of the hearing and the court in general is a way for the family to come out of that courtroom working together in the best interest of the family. And that's all you got to do. I mean, if you take your approach from that, with that principle at hand, then you will come across as the reasonable, the parent that really would defer to for the court, and you're going to be less stressed. You're going to get what you want, and your family's going to be thanking you for it in the end.
Yeah, definitely. Because I think of, and I'll name one by name because I really, really like all my appearances in front of him, Commissioner Gassner in San Bernardino County. And of any judge that I've ever been in front of, he sits there and he takes time and he customizes solutions. He's the one who, like, tell me about the kids. Tell me what's going on. Okay, Mom, what's your concern with this? Well, what if we did this? He's actively involved in part of the process.
Right.
I think you're far more likely to get a judge who's, I've read the pleadings, is there anything else? And they slap something on you. But so we really have those three. We have the ones who don't want to make a decision. Mm-hmm. They're going to tell you, hey, go in the hallway and figure it out. This is what I'm leaning. I need you guys to bring me something back in. There's the ones who are really going to get involved and actively be involved in that conversation. And there are the ones who are going to say, is there anything more than that's in your pleadings that I need to know?
And on those, what I really focus on a lot, there's two parts to your family law case: before court and in court.
Yep.
And a lot of times I can win a case before the hearing's even started, based off what I write and what I present to the judge in the moving papers or the responsive papers. I know that all I have to do when I get there, I don't have to say anything because it's already been said in my papers. And if the court has read what I've already said, then it's up to opposing counsel. They're in the hot seat, and I'm just there. The judge is already on my side and already taken my what I want. So my work's already done. And so
or the ones who give tentatives before you walk in, you have the court call and they already have what their tentative tentative ruling is.
Right.
No, I think that's the wild part about family laws. There are some judges that my joke would be is like you could just cut your finger and bleed on the pleading paper, and it would be the same thing as spending 6 hours drafting the perfect declaration. And then there are others that if it's not written exactly the way it should be in the declaration, it's going to be an issue.
Right. And if the judge doesn't read your stuff, that happens. I mean, judges are notorious for not reading their things. And hey,
every judge reads every word of everything that gets filed.
And if they don't, that's their prerogative. It's our job as attorneys to understand that happens. And how are we going to still present your case in a way that we can still get your day in court and get the important facts to the judge so that they can rule in our favor?
Yeah. So let's move on and say, regardless of what type of judge you have, which I can tell you if you're talking to Raphael and you're going into Lamoureux Justice Center, if you're talking, we're in our Crone office right now, if you're talking to one of our Inland Empire attorneys about a Riverside, San Bernardino, Hemet judge, they're going to know which way that judge leans. But regardless of that, what are some tips you can give to dads about what can be done to ensure that that judge is getting what they need and what they want to make a good, sound decision?
So I think the first thing is to, family law you have two parents who obviously don't get along, and their emotions are high.
Understatement.
The kids are involved, money's involved, and there's a lot of emotions involved. And the court sees a million people all the time, and what makes their life easier is if you have one side of the aisle that is not at each other's throat, and if you have one person that's just a pit bull over here, and then you have a guy that's just killing them with kindness and
standing firm. We're not saying give in.
Oh, sure,
but standing firm and not being emotional.
Well, there's a time and a place. Initially, I think the best approach, especially when you have someone that's being really hot and aggressive, and you have nothing to hide, and say, look, here's where we are, here's where we're coming from. If there is an issue that we have to get, get the gloves come off, then yeah, we'll get in there and we'll get dirty too. But if you are very strategic in when you do that, when you do become aggressive, it has a lot more weight as opposed to just being aggressive on every issue. And then the judge says, this isn't that big of an issue because you're aggressive on every little thing. Yeah. This guy over here is that when he actually speaks aggressively, he means it.
It's the client and the attorney both. Mm-hmm. One of the things I always push on attorneys here is that you don't need to run out and be a bulldog day one and pick every single fight. The number of cases that get resolved favorably for our clients because the attorney's stoic, the attorney doesn't play into certain counties. We'll just say Orange County is a little more litigious than the IE. And there are certain attorneys who are known, they bait, they're gonna get in, they're gonna scrap and claw from day one. And a lot of times you can get really, really favorable outcomes by just being a stoic and really focusing on what the goal at hand is.
If you're solution oriented and you present the judge with a family focused, child centered solution, you have a hard time walking out of that courtroom with anything.
Let's go deeper on that.
Yeah.
Let's go deeper on that because we talk about how much emotion is in family court, and it's going to be the most emotional time. And no one ever gets married or has a kid and it's like, we're going to end up in that courtroom one day. Like that's the last thing on your mind. Well, at least I hope it is. But talk about being child-focused, being family-centered, being solution-oriented, and how that can impact a case.
And I think the first step is saying, look, I may not be best of friends with my wife or the mother of my children, but we had a child together, and we gotta raise that child. And
18-year contract, and you didn't sign it with a pen.
And beyond that, I mean, it's never gonna end. I think you have to say, look, good, right, wrong, or indifferent, it didn't work out. What are we going to do? What does this child need from both of us to make sure that divorce or that separation doesn't affect their lives long term? Yeah. Because if you if from day one you come across as the parent that is doing your best to not involve them in the case, to make sure that they have what they need after separation, so that nothing is really affecting them and the consequences of the separation, and the judge sees that, then you're going to get a lot more favorable results that you want, as opposed to a longer road ahead of you in terms of baby steps to get ultimately what every parent should get, which is a 50-50 or primary custody.
Yeah. Well, some judges will actually ask the why question. I always push clients, and when they say, this is what I want, asking the why question, because there are those judges and commissioners who will, hey, can I talk to your client? Why do you want that? And if you don't have a good family-centered, child-focused reason for that request, it's kind of one of those, it's strike one in your case. Like, okay, this person's out for themselves. They're not about what's going to be best for the child.
And the easiest trap to fall into is the beginning of your case starts with a child support request. And then coincidentally, we want to change custody and visitation. And we have to make sure that, as valid as your custody and visitation rights are, we have to make sure that we don't come across as only wanting it to reduce your child support.
Yeah.
And there's a right way to do it and a right way to present it, so that you make sure that you're not coming across as you're still coming across as an interested father, not as I'm trying to just reduce my support.
Well, and a lot of times I'll give the advice of, if we need to adjust child support and you also want more custody, sometimes you have to make the strategic decision to look at the client and say, it's going to increase the likelihood of getting the right custody order in place if we just file for custody. And then once custody's changed, then that opens us up. So you're going to have 3-4 months where you're going to pay the amount that, hey, maybe you're paying an extra $100, $200 a month. But that $600 is going to make that first request just about the kids, and then we can fix the finances on the back end.
Right, and you don't want opposing counsel to say, Your Honor, this is just a financially motivated request.
Yeah.
He doesn't want to do this. And then now we have to kind of sort of run the defensive, whereas if we kind of eliminate that from their argument, we just focus on what we want.
You take their sword away.
Exactly.
They now they're just going to defend your request. They don't have anything to hit you back with. And
I've had a case recently where the court said we already wrote our pleadings and we said it very clearly, and it's very simple. My father was very basic, simple, reasonable request. He had no issues or reasons why he shouldn't have 50-50 custody. And when we get to court, the judge was saying to opposing counsel, "What's your reasoning? Why can't he have more time?" And she would come up with silly.
I love when judges ask why.
Yeah, and me and my client, we're here just looking at opposing counsel,
trying not
sweating
to smile.
bullets.
Yeah, trying not to smile, trying not to pat him on the arm.
Right.
Like, this is going the right way.
Right, and we're smiling, nodding, we're letting it go, but we don't have to. We're not worried about the support yet, because the support is just the numbers. It's the visitation and the incomes. Yeah. That's just what it is. What it is. So let's focus on what matters, which is your visitation, and that's the most important part at the end of the day. Money comes and goes, unfortunately, and in family law, as we all know, it's not cheap, and but it's worth it in the end. Your family is worth every penny, I believe. So
yeah, those are the types of hearings when they go that way. The client's like, "Well, why didn't you say anything?" Like, we got everything you asked for.
Right.
Like I was taught, if you get what you want, you walk away from counsel's table and you say, "Thank you, Your Honor."
Yeah, the last thing you want to do, I've seen before, where the case is going your direction, and the attorney that is going in their favor gets emboldened a little bit, and they start talking and they say the wrong thing, and the judge says, "You know what? I don't like what you just said, so I'm going to basically backtrack and go the opposite way here." Yeah. So you don't want to do that. And also, a lot of times, the things that you want to raise are not always relevant. They may be important because you want to get your
say it for the people in the back.
they may be relevant because you feel like they're important for the judge to know, but when it comes down to what is at hand, it can
Family code don't care.
It sometimes is a red herring, and it stirs the pot, it pours gas on the fire, and we don't need to go there.
Yeah, I was always told is you pick your percentage. If you get, let's say you say, hey, if I get 80% of what I want, I'm closing my binder. I'm telling Your Honor, thank you, Your Honor, and I'm walking away so they can't change their mind.
And the other thing is that judges in family law, it's so discretionary. It's such a gray area of law that they don't want to make sure that they want to see an outcome where neither party's walking out of that door feeling that they won. So they kind of split the baby a lot of times. They want to make sure that neither parent wins or loses. They each kind of win a little bit and lose a little bit.
Yeah, it's like, hey, I get it. This year you wanted Easter. You're not going to have Easter, but we got you more custody every other week of the year. Like, this is the way of the judge splitting the baby in a case like that.
And it's up to us to make sure that how that split happens is in a way that we make sure that it's child-centered and family-focused, so that at the end of the day, the family's in a much more functional spot than it is before.
And we know where the client's priorities are. And so it's like, hey, would you rather have an extra 6 hours on Easter, or do you want an extra day every single week this entire year?
Right. And a lot of it's just about planning, like who's driving where. You know, that's something that could be at the crux of everything. And it's such a simple issue that we can just solve.
Which gas station you're doing the exchange
exactly.
or something, yeah.
Yeah, so who's driving in traffic? So there's things that we can do that we can identify. Here's what is really the issues to litigate. Yeah. This is the small stuff. We can deal with that. And so we can narrow the focus and cut the waste of time out, because a lot of times you can spend forever in family court.
Yeah.
But you can also do it without even stepping a day in court at all. If you just do a stipulation, you can identify what you can resolve, and you never have to go to court at all.
I'll say this: the happiest separated couples, post-divorce, post-separation, are the ones who, at max, you have 1-2 hearings, and then you're able to work together.
Yeah.
The 0 hearings and co-parent is much easier than 8 years in court, 2 trials, 6 sets of abuse allegations later. Like, you're never going to successfully co-parent.
And I think about how much money those parents spent on attorney's fees, and how much money, take that amount of money and think about how much it could have gone to your kids. A college fund. You could have paid for them to go to college for all that money you spent on attorneys.
Yeah. And I promise you, with us, if you will agree to a stipulation, we don't need your money. Like, we're going to finish your case. We're going to get you where you want to be. And there's plenty of people that we're going to be able to impact.
Right. And I think I try to make sure that we don't go down a hearing or a path that is going to waste the parents' time. I'm very conscious and aware of how much you're putting into this. This is your life. Yeah. This is your money. This is your family. And I don't take that lightly.
Definitely.
And it's very important that I don't waste your time. I don't steer you in the wrong path. I don't waste your money. That's very important that we are conscious of that as attorneys, as your attorneys.
Definitely. Well, Raphael, thank you to all our viewers and listeners. I hope you learned a ton today from Raphael about how a judge can impact your case. And we'll see you guys all again next week on the Father's Rights Playbook.